Welcome to this explainer. Today, we're looking at the ultimate legal roadblock. We're examining a really fascinating document from the Constitutional Court of South Africa, Case CCT 29/00. It perfectly illustrates what happens when the unstoppable force of one person's determination meets the immovable object of a Supreme Court's final ruling. So we're going to break down how a supreme judicial body handles a flat-out refusal to accept defeat, and the profound legal principles that guide those decisions.
Okay, let's dive into this. Imagine exhausting every single avenue, right? You've climbed the ladder of the legal system all the way to the very top, only to be told, your journey ends here. Now, for most people, well, that's the end of the road. But what happens when you just refuse to accept that final no? What if you literally go back to the exact same judges, asking them to undo their own ruling? It creates this incredibly unique tension between a citizen's absolute belief in their right to be heard and the legal system's absolute need for boundaries.
So here are the opposing forces in this dispute. We have our applicant, Delene Johanna Levy, who is pushing the momentum forward. Defending the status quo are the first respondent, Daisy Marianne Glynos, and the second respondent, Azar Jammine. Now, we are going to look strictly at the procedural standoff between these parties. We'll be objectively examining exactly how the court navigated this highly unusual conflict without taking any sides in their underlying dispute.
This entire standoff stems from one specific catalyst, the August 15th order. Prior to this, Delene Johanna Levy attempted to appeal a judgment, and the Constitutional Court formally refused. They closed the door. But Levy didn't just ask them to reconsider. She lodged a notice of motion to set aside that August 15th order, and she actively requested to address the court directly. I mean, it's a bold move. And the court's response, it was swift and it was absolute.
Those are the exact words from the judgment. The application is both procedurally and substantively insupportable. This perfectly captures the stark, uncompromising reality of the legal system. The court isn't mincing words here at all. When they say it is procedurally insupportable, they mean the rules of the court simply do not allow for what she is trying to do in the way she is trying to do it. And when they say it is substantively insupportable, they mean that even if they totally ignored the rules, the actual meat of her argument, the content, the facts, the merits, it has zero legal backing to succeed. It is a complete blockade on both the technical front and the factual front.
To really understand that harsh conclusion, we have to look at the cold mechanics of Rule 1811B of the Constitutional Court rules. This is exactly how the court filters its massive caseload. First, an application is lodged. Then, and this is absolutely crucial, it is considered summarily. This means the judges look at the application without hearing any courtroom arguments, and they make a decision right then and there. Finally, it's dismissed on its merits. This filter ruthlessly weeds out cases that just don't meet the legal threshold to move forward. And what is that threshold exactly? Well, the previous unequivocal order from August 15th was based strictly on this premise. The court believed there was no reasonable prospect that an appeal will succeed. You see, courts don't grant appeals just because someone is unhappy with the decision. They grant them when there is a genuine, arguable legal flaw in the previous judgment that might actually lead to a different outcome. By stating this, the Constitutional Court declared that engaging in a full appellate process would just be a fruitless exercise for everyone involved. The legal avenue was, officially, a dead end.
Now, what's really interesting about this slide is that it reveals the philosophical anchor of this entire ruling: finality and litigation. Imagine playing a board game where the losing player can just demand you reset the board and play again, forever. The game would be a total nightmare, right? The legal system works the exact same way. Finality ensures that once the highest authority has spoken, it's over. It brings certainty, protecting the broader public interest by keeping the justice system moving and maintaining trust.
Listen to the intentional, forceful repetition in the court's judgment here. It was dismissed on its merits finally, once and for all. The judges are hammering the nail in as deeply as it can go to eliminate any ambiguity. They are making it crystal clear to the applicant, to the respondents, and to any future legal scholars reading this document that the door was not left slightly ajar. It was slammed shut, locked, and the key was thrown away. But behind these strict rules, the court has to maintain a delicate, very human balance. On one side, the court explicitly acknowledges the applicant's sincere belief in the justness of her cause. And we get that. Absolute conviction often drives people to push boundaries. But on the flip side, the respondents are, as the judgment states, entitled to get on with their lives. The court absolutely must balance the emotional drive of one individual against the fundamental rights of the others to finally have peace and certainty. So, you might be wondering,
Is it completely impossible to reopen a final order? Well, in principle, a final and definitive order of this court will only be reopened if two incredibly strict conditions are met. There must be exceptional circumstances, and there must be compelling reasons. It can't just be new arguments or a really passionate plea. It has to be something extraordinary, like a massive miscarriage of justice or maybe newly discovered evidence of fraud that fundamentally shatters the original ruling. In this case, the applicant submitted a founding affidavit and subsequent letters to the court, but the court found that the grounds advanced in these documents were neither exceptional nor compelling. They totally failed this rigorous test.
Because she failed to provide those exceptional reasons, the court reverted back to its highly efficient filter under Rule 1810. They didn't call her in for a hearing. They evaluated her new letters and affidavits summarily and concluded they were entirely without merit. Despite her sincere belief that she was right, the court stated plainly that there was zero reason to believe their previous refusal of leave to appeal was wrong. The original judgment stands firm.
And this brilliantly illustrates how a summary dismissal, which, let's be honest, might seem incredibly harsh and cold on the surface, actually serves the interests of everyone, including the applicant herself. In the legal system, when you lose a case, you are often ordered to pay the legal costs of the other side. This is called an adverse costs award. By summarily refusing this application, the court explicitly noted that they were protecting the applicant from the risk of racking up even more financial penalties. If they'd allowed this to drag on into a formal hearing, only to ultimately rule against her again, the financial devastation to the applicant could have been severe. So in a way, the court is essentially protecting her from the consequences of her own relentless pursuit.
Which brings us to the final conclusion of the document. The definitive order reads, "The application to set aside the order of this court refusing leave to appeal is dismissed. There is no order as to costs." True to their reasoning, the court dismisses her attempt entirely, but mercifully decides not to punish her financially for making the attempt. There is no order as to costs. It is a firm, undeniable ending to the dispute, wrapping up the procedural facts of case CCT 29/00 neatly and finally.
As we wrap up this explainer, I really want to leave you with this thought. We so often equate justice with giving everyone a chance to be heard, over and over until every single stone is turned. But as this constitutional court ruling demonstrates, an absolutely essential component of justice is knowing when to say enough. The machinery of law literally requires an endpoint to function. So looking at the balance between an individual's burning desire to vindicate their cause and society's absolute need for stability and closure, I ask you, is true justice found in endless appeals or in the certainty of a final conclusion? Think about that next time you hear about a major court decision. Thank you so much for joining me, and keep exploring the structures that shape our world.